The first thing, I just want to introduce the center that I co-direct with my colleague Don Steeman. If you're not familiar with our work, there's a QR code up here that you can go to and sign up to be on our newsletter distribution. We send a newsletter out roughly every month or two. And the way that we approach our work is as soon as we have research findings that we are confident in, we put out research briefs. So we're really trying to inform the field as we learn things, both about the Pretrial Fairness Act evaluation work that we're doing, but a lot of other projects that we're doing as well. So the center was established at Loyola in 2015. We work directly with stakeholders, practitioners, policymakers to carry out research and answer questions that they have about things. We are nonpartisan, we're objective, we are here primarily to provide good empirical research from which they can then make decisions. So I want to talk a little bit about the evaluation that we're doing. We embarked on a long-term evaluation of the implementation and impact of the Pretrial Fairness Act a couple of years ago. Our goal is to carry this research out at least through the first couple years of its implementation. The research is supported by the National Institute of Justice as well as some foundations. The approach that we're using, and I'm providing you with a little bit of context just so you understand from where do we reach some of our conclusions. We're conducting the research by doing interviews with practitioners and stakeholders that are directly involved in implementing the policy. We've done interviews with individuals who are going through the pretrial process. We're also observing court hearings where bond decisions were made before the law and where detention and conditions hearings are being held after the law, and then we're analyzing, obviously, a lot of data. The focus of our evaluation is on 33 counties in Illinois. They're highlighted in blue. And by focus, I mean in those counties we are trying to do court observations and interviews and analyze data and really get a full sense of how the law is being implemented. But we're also collaborating with other stakeholders, including the Illinois Department of Corrections Jail and Detention Standards Unit. They collect some information about jail populations that we work with them to analyze and create a data dashboard with. And we're also working with the Office of Statewide Pretrial Services. And I'll talk a little bit about the Office of Statewide Pretrial Services because that's one of the more significant changes we've seen in Illinois, particularly outside of the Chicago metropolitan area. And it's also their data that we're relying on a lot for some of the analyses that we're going to share with you. So I mentioned the collaboration with the Department of Corrections Jail and Detention Standards Unit. We've created a data dashboard. The website's on here, and the PowerPoints will be distributed to everybody after today. But you can go to that website and look at the volume of people being processed into jails throughout Illinois. You can pick a specific jail to look at the volume of people. And we really set it up so that we can see in near real time what's been the impact of the law on changing jail admissions and populations. We've also been working with the Office of Statewide Pretrial Services since it was established a couple of years ago. The map shows you what counties the Office of Statewide Pretrial Services provides their services to. There's a couple counties highlighted in yellow. Those are counties that will be kind of coming under the fold of the Office of Statewide Pretrial Services later this year. But what the Office of Statewide Pretrial Services does is in the counties they're working, they go into jails and interview individuals who've been held overnight prior to their appearance at either a bond court hearing prior to the law or after the law that appear before a judge for setting of conditions or consideration of detention. Most of the counties that the Office of Statewide Pretrial Services is in did not have any type of pretrial service capacity prior to their creation. In other words, in many of these counties or in most of these counties, when judges set bail decisions, they didn't have an independent entity providing them with information about the defendant's risks or concerns. So we're working with them, we're analyzing their data, and so a lot of what we're going to present here is focused on those 77 counties for which we have data from the Office of Statewide Pretrial Services. So getting into a little bit of the findings that we've got. So the first thing that I wanted to highlight is we've been observing the hearings that defendants go through to set bond or to have their conditions of release or detention decisions made. We've observed almost 2,000 defendants go through this process before and after the law. So the way we're doing the research is we did a lot of analysis to understand what was going on prior to the law. Now we're looking at what's going on after the law and allowing us to see what's changed since then. Most of the observations of the hearings have been focused in Cook County and the larger urban counties for a couple reasons. One is proximity to where we are, but also just the logistics of having sufficient cases to observe. One of the things we realized, and I'll show you some data on it later, in most of the rural counties in Illinois, they have very few hearings during the course of a week or a month. And so for us to go down and observe a hearing, we might go down there and be waiting for a week before we have an opportunity to actually observe. So the information is a little bit more skewed towards the urban areas. But what we did was we sent researchers to the courtroom. They had a structured data collection instrument where they captured detailed information about every defendant's hearing. How long did it take? What kinds of arguments were being made by the prosecution and defense? What were the comments being made by the judges? What factors were being considered? The conclusion we've reached from those observations is the length of the hearing when detention is being considered have gone up dramatically. And so prior to the law, when the prosecution was seeking the defendant have to pay a bond in order to be released, we consider that a hearing about detention. And then we compared it to the detention hearings afterwards. In Cook County, the median length of time for these hearings went from about 4 minutes prior to the law to about 16 minutes after the law. So it increased essentially by a factor of 4 in terms of the duration of the hearing. And that was something we consistently saw across the counties that we observed. Right. The other thing that we found was there's a lot more discussion at these hearings by all parties of a much more varied set of topics. So before the law, what we frequently heard was primarily reference to the charges and the defendant's criminal history. Those were the two things that were primarily discussed. After the law, we're now hearing a lot more discussion about the strength of the evidence, which is one of the things the judge has to consider in reaching a decision about detention. We're also hearing more reference to risk assessment scores and things like that. So it's clearly changed what's being discussed and deliberated during these hearings. And then the last thing that we've observed is when the judge reaches a decision, they are being much more specific and clear and providing much more detail as to how they reach their decision. Again, prior to the law, usually what they would say is, I'm going to set bond in this amount, and that would be the extent of it. Now when they're reaching a decision, they're articulating why they reached that decision, what evidence or what factors they considered and why they use those to reach the decision. Part of that is likely because this is a new law. There are a lot of legal challenges on individual cases as to whether or not the person should have been detained. And it's likely that judges are trying to establish a clear record for those subsequent appeals. But part of it is also that the expectations of what is considered during the decision to detain are much more clearly articulated in the law, and the judge is likely trying to ensure that they kind of touch on all those things that have to be considered. So those are from some of the observations. The other obvious observation that you don't need to be a researcher to understand is there is no longer any discussion of money at these hearings. So the discussion about how much a defendant will have to pay is no longer part of the discussion. Prior to the law going into effect, statewide, about $140 million each year was paid by defendants in the form of posting money to secure their pretrial release. No longer are they posting money to secure their pretrial release. So $140 million is now remaining in the community, in the pockets of the defendants, but in most instances, more likely their family, their friends, their parents, right? So getting into a little bit about the types of cases that are processing through the system that are eligible for detention. So under the law, there's essentially two categories of defendants that can be detained pretrial. There's a category of defendants that are charged with an offense which is deemed to be potentially a public safety risk if that defendant were to be released. That's one group of offenses, and that's what we're focusing on. The other group of cases is anybody charged with a Class 3 felony or higher could be considered for detention under a willful flight consideration, meaning the prosecution would have to show that the defendant poses a risk of fleeing the jurisdiction to avoid prosecution. In the observations we've made in court, we've observed very few cases where that is the argument. So they really are focused on the public safety consideration or that category of defendants. So this is information that comes specifically from the 77 counties that the Office of Statewide Pretrial Services is serving. Among those who are eligible for detention under the public safety consideration are people charged with domestic battery or violating an order of protection, other non-probationable felonies, violent forcible felonies, and illegal possession of a firearm offenses. So that broadly makes up the category of crimes for which you can be considered for detention under the public safety consideration. Among these 77 counties, you can see here 40% of all the people that are eligible for consideration of detention are charged with a misdemeanor level domestic battery or violating an order of protection. Another 15% are charged with a felony level domestic battery or violating an order of protection. So in total, about 55% of all the people in these counties that are eligible for detention consideration have been charged with a domestic battery or violating an order of protection offense, which is actually something that we projected prior to the law based on arrest patterns throughout the state. We suspected that domestic battery cases would account for the majority of these cases. But you can see where the other offenses fall. A relatively small share of all those eligible for detention are people charged with non-probationable drug law violations and non-probationable property crimes like residential burglary and things like that. So that's kind of the pool of people that are eligible for detention. What we've looked at is of those people that are eligible for detention, how many are being petitioned to be detained. So the process is that if the person's eligible for detention, the state's attorney can file a petition asking for a detention hearing. If that petition is granted, then there's a detention hearing where the judge determines, based on the evidence, whether or not the person will be detained or not. As you can see in this figure, about 43% of all the people that are eligible for detention consideration are not having a petition filed by the prosecutor for a detention hearing. In other words, based on their review of the case, they don't feel that seeking detention is necessary. Right? The other thing that's likely factoring into their decision is the information that I presented earlier, that the detention hearings do take a substantial amount of time. So they're likely having to balance what is the need for detention from the standpoint of ensuring public safety, but also do we have sufficient resources and sufficient time to have these much longer hearings that are going to take place. Right? So more than 40% are not even petitioned for detention. 22% have a petition for detention filed and a hearing held, but after that, the judge determines that detention is not warranted. And then the remaining 36% of this overall group are actually detained, meaning the judge reached a decision that detention is warranted in this particular case. It's important to note is that this is the detention decision that the judge makes at that point in time. Detention has to be reconsidered at every subsequent hearing. We haven't gotten into that yet, but it's likely that a portion of these defendants may be released at some point in the future. It's also possible that the people that weren't petitioned or whose petition wasn't supported may be brought into detention because of violations of their pretrial release. But this at least gives you a sense, out of all the people eligible for detention, about a third are actually being detained. One of the things that we looked at was we tried to examine what are the characteristics of the defendant or the case that increase the likelihood that the person would be detained. So what we're looking at here is, out of all the people eligible for detention, what specific characteristic increased or decreased the likelihood that they would actually be detained? So defendants that were charged with a felony level offense, a felony level detainable offense, almost half of them were detained. Right? Of those charged with a misdemeanor detainable offense, it was closer to 15%. And just to kind of provide some context, Almost all the misdemeanor offenses that are eligible for detention are misdemeanor domestic battery or violating an order of protection. So the seriousness of the crime from a legal classification was the strongest factor that predicted whether or not someone would be detained, the higher the level of felony. In addition, if the person was on supervision at the time of the offense, meaning they were on probation or they were on mandatory supervised release from prison, that also increased the likelihood that they would be detained. Males were more likely than females to be detained. Defendants in urban communities of those served by the Office of Statewide Pretrial Service were also more likely to be detained than defendants in rural areas. And then interestingly, just as a way to think about the implementation of the policy, defendants that were moving through the system in the first few months of the effective date of the Pretrial Fairness Act were slightly more likely to be detained than those moving through the system in the last 7 months. And that likely reflects the newness of the law, everybody trying to figure out what they're doing and where it's appropriate, but we saw slightly higher rates of detention during the first few months of implementation. So this gives you a sense of what individual defendant and case characteristics influence the decision to detain. But we have to recognize that Illinois is a pretty diverse state. Each individual county, these decisions are reached by independently elected state's attorneys, locally elected judges that respond to the local environment and the norms and kind of the approaches there. Like I said before, in rural counties, the volume of cases is relatively small. So about 2/3 of the counties served by the Office of Statewide Pretrial Services had 10 or fewer cases that were eligible for detention consideration each month since the law went into effect. Right? So on average, they're only having about 2 cases a week that are even eligible for detention consideration. So we've got to kind of recognize that volume in many counties is pretty low. But we see a large variation in the percent of defendants detained across individual counties. So listed here are the counties that had at least 100 detention eligible cases going through their system since the law went into effect. You can see in some counties, close to half of all the defendants are being detained. In other counties, 15% or fewer percent of the defendants are being detained. We intentionally didn't put the names of the counties up here because our point isn't to identify which county is high or low. It's just to illustrate how much variation there is across the state. The other thing that's important is some of this variation is explained by differences in the composition and the nature of the cases that are moving through those individual counties. So in some of the counties at the top end, they are very different in terms of the types of cases that are moving through their court. More serious felonies, defendants with more extensive criminal records that are on supervision that kind of elevate the likelihood that they're going to be detained. And then some of the counties at the bottom end primarily have misdemeanors and defendants without as extensive criminal histories. So some of that variation is explained by that. But even after we account for that, there is still some variation, which again reflects the unique nature of kind of the fragmentation of the justice system in Illinois and the fact that this is a statewide policy, but it's being implemented in every individual county based on those counties' kind of norms and expectations. Right. One thing that we've started to look at is of the people that are moving through the courts, have we seen changes in the rate at which defendants are not appearing in court? So here we're measuring the failure to appear rate of defendants that are going through the court. This is for a subset of 21 counties where we've gotten the detailed data and have been able to analyze it at this point to make these conclusions. Essentially what we're seeing is the failure to appear rates have not really changed, right? You'd say 17 to 15% went down. For us, that's about the same, right? It's statistically very similar. In Cook County, based on public data that the Office of the Chief Judge has posted, their rates of failure to appear to be about similar to what it was prior to the law going into effect. Keep in mind, this is early in the implementation of the law. We're only, in quotes, only a year into it, but a lot of these cases that are moving through the system have not yet reached resolution. Particularly the more serious felonies, they won't reach resolution. So we've got to kind of be a little bit patient to wait for enough of the cases to actually reach their end before we can make a lot of definitive statements about what was the overall rate of failure to appear. The other, I think, important piece of information to put this into some context, the Office of Statewide Pretrial Services has a data dashboard that they update every day. On there, they post failure to appear rates as well, since the law has gone into effect. The important caveat is it's only the cases that they are supervising. So it's not every case going through the counties, it's just the cases that they've been ordered to supervise, but at least it's some helpful context that in those counties, collectively, the failure to appear rate's around 5%, which is obviously a lot lower than this. Some of that likely reflects the conditions of supervision, and the processes of supervision include things like text reminders and making sure a defendant can appear in court, and if they can't, making arrangements to assist them in appearing, for example, if they need transportation or things like that. The other thing that we're looking at is how has the implementation of the law had an impact on jail populations and jail bookings and other supervision populations pretrial. Prior to the law, there were as many hypotheses and predictions about what would happen as there are people. Right, so there were people that said jail populations are going to go up. There were some that said jail populations are going to go down to zero, meaning everybody's going to be let out of jail. There were some people that said, I don't think it's really going to have any impact on the size of our jail population. So there are a lot of predictions. There were many people that expressed concerns that if we see a drop in the jail population, are we going to see an increase in other pretrial supervision populations, like those placed on supervision or those placed on some form of electronic monitoring. So those were also some things that we looked at. This gives you some information about what's going on across the different parts of Illinois with respect to jail populations. So what we've seen since the implementation of the law is jail populations are down about 14% in Cook County. They're down about 14% in the other urban areas outside of Cook County, but they're down 25% in Illinois' rural jails. So, what's going to happen with jail populations? I think our general conclusion is jail populations have gone down. It's not to say every county's experienced a decrease, right, or as big a decrease. There's some jail populations that have some county jails that have actually seen increases in their population, but when we kind of lump all the counties together, we see this pattern of decrease. The drop in the rural county jail populations that's larger than what we see in other parts of the state was also something that we suspected we might see based on our interviews with stakeholders in rural communities and analyzing some of their data, because a lot of the people processed through their jails are people charged with things like drug possession and theft cases that aren't eligible for detention. And so we suspected that we'd likely see some of that drop. So the jail populations went down. What happened with the pretrial supervision populations? And so there's a lot of information up on the screen. I'll kind of walk you through it. Before I had animation where I'd just bring up each piece, and that was too cumbersome. So I'll animate it on the fly. So what the graph is showing you is what is the trend in jail populations in the counties that are not covered by the Office of Statewide Pretrial Services, and it's not Cook County. Right? So it's primarily the urban areas outside of Cook County. The jail populations in those counties is down by about 500 people since the law went into effect. The number of people on pretrial supervision is up by about 300. Right? So we've seen some of that predicted shift, right? Fewer people in jail, more people on pretrial supervision. If we look just at Cook County, the Cook County jail population is down by about 900 people. The number of people on some form of pretrial supervision or electronic monitoring is up by about 2,200 people. So in Cook County, we actually see kind of the, in quote, the footprint of pretrial supervision and custody has increased a bit. Right? Most people would say better they be in the community under supervision than in jail where they can't work and provide for their family. But in Cook County, we have seen this shift. In the counties served by the Office of Statewide Pretrial Services, it's kind of a complicated question to answer. The jail populations are down by about 400, but the pretrial supervision populations are up by about 1,500. The important caveat there is the Office of Statewide Pretrial Services only began providing supervision as an option for those counties in 2023. And so many of them are still essentially growing their pretrial supervision population as they start implementing that practice within their county. What we see across all the regions, for the most part, is there's about a 2-to-1 ratio between the number of people on pretrial supervision in the community and in jail. Right? That ratio is consistent in these counties, in Cook County, and then in the Office of Pretrial Services County. Right? So there's the majority of people under some form of custody pretrial are in the community. The last thing is most people who are awaiting disposition of their case are neither in jail or on pretrial supervision. And that was the case before the law went into effect as well. Right? So kind of all told, when we combine all this, jail populations are down about 1,800 across the state. The number of people on pretrial supervision is up by about 4,200. One thing that we found, and we're actually tracking it every day, if you go to this website, we update it every day. It's specific to Cook County, but it's how many people are in the Cook County jail and how many people are in electronic monitoring in Cook County. The number of people on electronic monitoring in Cook County has actually gone down since the Pretrial Fairness Act went into effect. And the jail population's gone down. So the fear that many had that we're going to see this explosion in the number of people on electronic monitoring hasn't occurred. But we have seen an increase in the number of people on pretrial supervision. So there is still that increase in supervision. It's just not the electronic monitoring that many people were concerned about. The last thing that I'll share with you is some analyses we've done of the degree to which GPS supervision is being ordered. And so again, this is derived from data from the Office of Statewide Pretrial Services. Most of the counties that they are serving, like I said before, never had pretrial supervision as an option because they didn't have staff to do that. They also didn't have GPS supervision as an option. One of the things that the Office of Statewide Pretrial Services is providing that's unique is that people can be placed on GPS supervision at no cost to the defendant and at no cost to the county. In many counties that previously had GPS supervision as a condition, the defendant was required to pay that fee, right? And in many instances, it was extremely expensive. So OSPS is providing that service to judges as an option for pretrial release. There was concern that this would be overused, and at least so far, it doesn't seem like it's being overused or used to a high degree. So just like with who got detained, who gets ordered to GPS supervision is also influenced by specific characteristics of the defendant. So out of all the people that were not detained, and this includes detention eligible and non-detention eligible folks, less than 10% are being ordered to GPS supervision. The strongest factor that predicts if they're ordered to GPS supervision is, were they petitioned for detention and that petition to detain was denied and the person wasn't detained? So these are people that they had a detention hearing on, the judge decided, I am not going to detain you. For those individuals, 1 in 3 were ordered to GPS supervision. And that's part of the discussion that has to happen at the detention hearing. Are there other conditions short of detention that can ensure public safety or can ensure court appearance? And obviously, pretrial supervision is one of those conditions that could be used, but global GPS supervision is kind of another rung higher in terms of that. Defendants who were charged with domestic violence offenses were more likely to be placed on GPS supervision than those that weren't. Males were more likely to be placed on GPS supervision. And jurisdictions with no jail also had a slightly higher rate at which people were ordered to GPS supervision. Just like what we saw before with a lot of variation across the counties, we also see a lot of variation across the counties in the extent to which GPS supervision is ordered. Again, some of that's because of the nature of the cases, some of it's just their local preferences and approaches. So I'll walk through kind of what I think are the key takeaways from the research we've done, and then we can, if you got questions, I'm happy to answer those. So a couple things that I think are important. First is the nature of these hearings or the requirements of these hearings has dramatically changed what things look like in the courtroom when an individual's pretrial freedom is being argued in court. The hearings are taking longer, but that's because a lot more evidence and a lot more argument across a variety of different factors is being made. And judges are being much more deliberate and articulate in talking about how they reach their decision. Most of those people who are charged with a detainable offense are not being detained. And again, that was a concern that some had, that everybody who's eligible is going to be petitioned to detain. That's not necessarily the case, but it varies from county to county. In some counties, most people who are eligible for detention are actually being detained, but that's not the norm. Jail populations are down, and it's down more in the rural communities. But the decrease in jail populations have been offset by increases in pretrial supervision populations. But we haven't seen an expanded use of electronic monitoring in Cook County. We haven't seen kind of an overuse of GPS supervision in the counties served by the Office of Statewide Pretrial Services. And then lastly, this isn't a definitive conclusion. It's not an empirically rigorous conclusion. It's just some simple analyses we did because we suspected people would say, has it had an impact on crime? We can't say whether it's had an impact on crime, but what we can say is during the first 6 months of 2023 compared to the first 6 months of 2024, crime is not up in Illinois. It's not up in Chicago. It's not up in other urban areas. It's not up in rural areas. It's not up for violent crime. It's not up for property crime. So crime hasn't gone up. Again, there's some counties that have seen increases in crime. Right? Whether or not that can be attributed to pretrial reform is a more difficult question to answer empirically. But at least we can say the crime hasn't gone up. Right? We'll continue to do research on this and develop a more sophisticated method to analyze it to make some more definitive statements about has this had any impact on crime, but at least to put it out there that we haven't seen increases in crime. That, again, for the general public, they always think the crime is going up, right? Based on research that's been done, most people think crime is always going up. At least we can say the crime hasn't gone up in Illinois. So I'll end there, and I'm happy to take questions that folks have. So.
I have a fairly unfair question.
Okay.
You are going to try to summarize your findings with this study in, like, say, about a paragraph or so. How would you describe that to somebody? What would you say? How would you phrase that for everyone? I'll
give you the sarcastic answer and then a more thoughtful one, because the sarcastic one's easier to come up with. Things haven't been as bad as people predicted. They haven't necessarily been as good as people hoped. Right? I think some people were hoping the jail populations would drop a lot more, right, and that we wouldn't see a shift towards other forms of supervision. But in terms of it not being as bad as people thought, jail populations didn't go down to zero. Not everybody's being detained. I think a more thoughtful kind of way to summarize it is there is no longer any discussion about a defendant's income and ability to pay in determining whether or not they should be released pretrial. So that's one thing that's gone. The other thing is that the hearings, when we're deciding to take away someone's freedom, are much more thoughtful and thorough and comprehensive than they were before. Right? And then lastly, we are seeing changes in the number of people held in jail. Right? There are fewer people being held in jail for relatively brief periods of time for minor offenses. That's why the jail populations haven't gone down to zero. There are still people that are being held charged with more serious offenses. And in many instances, they're being held longer now than they would have before the law. Because prior to the law, if they could come up with the $10,000 or $15,000 and they were charged with a pretty serious offense, they could post the money and be released. Now they can't come up with money to buy their way out. They're going to be held until a judge determines that the case is resolved or the defendant can be released. So I'm not sure if that's a paragraph for you, but I think the highlights are the court processes have changed. It's clear that the factors driving the decision are not random, right? They're clearly driven by things that you would expect: the seriousness of the crime, the nature of the defendant's pretrial status in terms of being on supervision, those kinds of things.
A common concern that a lot of states' attorneys expressed, at least down here before the Pretrial Fairness Act was implemented, was the workload that would be added to their offices, having to go through those more detailed, thorough hearings, as you discussed. Just in your discussion subsequently with some of these states' attorneys, especially in some of these smaller downstate offices, what has the impact been on workloads? Has the amount of, detainable offenses maybe dropped that, or what? Just what's been the overall impact?
Yeah, I think there's a couple ways to think about it, and really it's going to vary by the size of the jurisdiction, right? There's plenty of counties across the state where there is a single state's attorney. He or she handles everything. For them, obviously, it's more work up front on a case, but they're going to be working the case throughout the duration. I think in some of the other larger counties where they have much more kind of segmented responsibilities, you've got assistant state's attorneys who review the case and make the argument for the case at the detention hearing. They aren't necessarily the same ones that's going to handle that case later on. So in those counties, what we suspect is likely happening is they're spending a lot of time up front on the case that they normally wouldn't. And while we think, okay, they've taken care of all that and now the case will go more smoothly, it's not the same assistant state's attorney that's going to get the case further down. So they're going to kind of have to revisit a lot of these things. The other way that we describe it is many people are describing this as a mini trial, right? The detention hearing is like a mini trial where they really are interrogating the quality of the evidence and a lot of other factors. But unlike trials where assistant state's attorneys and public defenders have months to prepare, in these cases they have hours to prepare, right? So there's a lot of work that goes into these. I know a lot of jurisdictions have shifted their practices where they've got assistant state's attorneys coming in much earlier to start reviewing cases and kind of put them into different tracks. So it is clearly an impact on workload because the hearings now are also taking a lot longer. In many of the counties, bond court was about an hour long. Right? It started at 1, it ended at 2. Now it starts at 1 and it goes till 5 o'clock. So those are staff that no longer can be floating around to other courtrooms. They're in that courtroom for half the day, and the other half they're preparing for those cases. So it clearly is having an impact on workload. A lot of people argue that, but it's going to make cases go smoother later on. We still have to kind of see that. But some of the things we've observed is cases where at the detention hearing, a judge decides to not detain, and part of their decision is the strength of the evidence. That likely is going to send a signal to the assistant state's attorney that there's questions about the case, right? Or there's questions about the evidence that might lead to dropping the charges more quickly or modifying the charges to lesser offenses. I hope that answered your question.
Kind of following up on that, have you seen evidence that there are counties that don't have the resources to provide GPS monitoring? They don't have the manpower to provide the kind of pretrial supervision that's being requested, especially in the rural counties.
Yeah. If the Office of Statewide Pretrial Services had not been created, the answer would have been yes. Right? Now that's no longer an issue. Right? A judge can impose supervision or GPS supervision without the worry of, do we have those resources available? Because the resources are being provided by the state. Prior to the Office of Statewide Pretrial Services, in most rural counties, the judge had no option for pretrial supervision. That capacity did not exist. So their decision was how much bond, and that's about it. They couldn't order supervision because it didn't exist. And if they're going to order GPS supervision, the defendant would have had to pay for it, right? Now at the Office of Statewide Pretrial Services, judges are allowed now to just consider, do I think it's appropriate to order supervision or GPS monitoring? I don't have to worry about the cost or the availability because it's being provided by the state.
So is that going to be an ongoing financial burden on the state?
Yeah, I mean, it's a responsibility now that the state has assumed, and you saw from the map, they're in I think 77 counties now. It's expanding as as counties that are running their own pretrial service functions are realizing, well, if the state can do this more effectively or more cost effectively, why don't we go with having the state provide it? But there still are counties, particularly the larger ones around Chicago, that have their own pretrial service units, and they're comfortable with that, and they're carrying out those functions as they would. So, it would have been really interesting to see what would have happened had there been no capacity for pretrial supervision in most of the counties. And what we suspect is it's likely that a lot more people would have been detained, because the judge, when faced with the question of are there other means to ensure public safety or appearance, they wouldn't have had other means. They wouldn't have had supervision or GPS to ensure that. So
I had a question about the data point. So of the nearly 9,000 cases detention eligible, 43% were not petitioned for detention. Mm-hmm. So I'm wondering, like in more rural counties or rural jurisdictions where they don't have like the people power to like man some of these cases, like is that like a possibility for why they're not even going through with these hearings?
It could be. I mean, part of it could be that. Part of it might also, what we've heard from prosecutors is they approach this decision seriously, right? They've got to have sufficient evidence to go into court and argue why they think this person should be detained. And if they don't feel as though they have the evidence, or they don't feel that it's appropriate, they're not going to waste the time and resources to go through these longer hearings if they don't really believe that it's necessary, right? So it really is focusing them on the cases that they think are the most serious. Part of it may also reflect, and this is something that we heard in our interviews with stakeholders, in rural communities, the prosecutors and the judges and the defense attorneys oftentimes know the defendants, and they know the defendant's family, and they know the defendant's circumstances. And so it's likely that in some of those jurisdictions, the decision-making isn't kind of an abstract of what do we do with defendant A, it's what do we do with defendant David Olson, who I know what he's going through, and I know his family circumstances and those things. So it may be that they've just got more of an intimate familiarity with folks in the community, and that may influence their decision as well. So
I was curious about like what you've been able to find with like more smaller like rural counties when it comes to cases involving drug possession and stuff.
Yeah. So in a lot of the rural counties, particularly in southern Illinois, a large share of the cases that go through the system are drug possession cases, increasingly or kind of disproportionately cases involving methamphetamine. The challenge there is those individuals cannot be detained because of the nature of the charge. A Class 4 drug possession offense isn't eligible for detention. And the concern by many was we can't detain them, so we can't hold them at all, but we also don't have a lot of treatment resources here to refer people to. So that is a challenge, and that's a concern that's been raised. The research that we did prior to the implementation of the law, though, found that most of those defendants did get out of jail within a week, right? Eventually, they were able to post bond or have someone post bond. So it's not like they were being detained for months. It's also important to recognize that detaining you isn't treatment, right? But a lot of them felt like, okay, if we can detain them for a period of time, get their minds clear, they may be more motivated to engage in treatment. The challenge is, though, that it still doesn't exist to the degree it needs. Again, with the Office of Statewide Pretrial Services, they can provide supervision. And if during the hearing that the judge has to impose conditions, they determine that a referral to substance abuse treatment or for a substance abuse assessment is appropriate given the nature of the case, right? They have to show that there's a nexus between the criminal activity and drug use. They can order that the individual be referred for an assessment and placed on supervision. Then the Office of Statewide Pretrial Services is responsible for making those connections. The Office of Statewide Pretrial Services is faced with the same challenge, though. If there's not a lot of treatment resources, making those referrals is challenging. And I know that they and their colleagues at the Administrative Office of the Courts have been working on how do we establish and enhance the availability of treatment services. And I believe there was an appropriation in the last state budget where there are some resources that have been put forward to provide some support for people who are released pre-trial to access some of these types of services. So hopefully that answers your question. The last thing I will say just about your question about the rural issues is also recognize that the law requires that detention hearings be held within a certain amount of time. And in a lot of rural counties, they don't have criminal court every day. They don't even have it every other day. In some counties, criminal court is on Thursday. So for them to actually assemble everybody needed to have a detention hearing involves a lot of logistics, right? They got to make sure that the part-time public defender is available, that the judge is available. And again, I think they're going to look at it and say, if this is kind of an iffy case as to whether or not we even think it needs detention, are we really going to try to do that? But I think they're going to say, if we think they need detention, we're going to seek detention, and if we have to assemble all these people, that's just part of the process. So,
first, the stat that stood out to me was that the number of people not showing up actually went down. Now, I know you gave the caveat; it's still early in the data collection, and most cases are still ongoing. But why do you think that is?
There's a couple reasons. One is that we have to recognize that did the law actually result in a dramatic change in the number of people that are released pretrial? All right. So if what the law did was say that fewer people are being held, and there's a group of people that otherwise would have spent 7 days in jail, now they're spending no days in jail, right? Do we really think that 7 days in jail during the duration of their case is somehow going to affect their failure to appear rate, or the rate at which they're charged with new criminal activity, right? So part of it is just recognizing, did this law really change in a dramatic way how many people are in the community pretrial, right? When we show that statewide, I forget the number, a couple thousand fewer people in jail, right, on any given day, out of the probably close to 100,000 pending cases, you follow what I'm saying, is why would we expect failure to appear rates to change dramatically when the number of people released pretrial really hasn't changed? We may actually see it go down, right, in some jurisdictions. Like I pointed out, the data from the Office of Statewide Pretrial Services shows for their cases that they're supervising, which is a subset, they have much lower rates of failure to appear. So kind of recognizing that, reminding people of court hearings through a text reminder can improve failure to appear rates. Communicating with the defendant to say, hey, you've got a court case next week. Are you going to be able to be there? And have the defendant say, I can't get a ride. And for someone to work out how you're going to get a ride, those simple things can reduce failure to appears. At this point, as you point out, it's tentative, it's early, but at least it suggests that it hasn't changed dramatically in one way or the other. So,
obviously, we're only a year in, and things are still ongoing. But is there anything in the past year that you've seen that maybe you would change from the Pretrial Fairness Act? Maybe things we can improve upon?
So I'm a researcher that does objective research. I'm not elected to make policy, all right?
That's fair.
What we're trying to do is evaluate how is this policy being implemented and what impact is it having. The idea with the work we do is we show it to people, and if people say, boy, we're not detaining enough people, maybe the requirements are too rigid, that's a debate for policymakers to have. If we were to find, and again, we may find things that suggest what improvements might be needed. If we found that the rates of failure to appear doubled, right, there's probably some policy implications around that, or implications for practice. But we haven't really seen anything that's shocking that I'd say, in quote, we're concerned about. For better or for worse, it's kind of middle of the road, conclusions, which a lot of policy evaluation is, right? There's not a whole lot that's shocking. I think the interesting thing that we found, that as we reflected, we realized isn't that interesting, is how much variation there is across counties in the rate at which detention is imposed. And part of that, as we reflect on it, we realize there's variation in decision-making across counties for all decisions. There's the same variation you see with respect to when people are convicted of a felony, how many people go to prison. There's some counties that send a large share of people to prison. There's some counties that send a smaller share. So it's all reflective of the local environment and the politics and who's leading those agencies. So.
The argument before this law was adopted is that cash is what secures a person's appearance for later.
Right. They
have an incentive. You show up to court because you want to get your cash back.
Right.
Does this data say that idea is fundamentally flawed? I
think there's research that suggests that idea is fundamentally flawed, and in our interviews we did with stakeholders before the law went into effect, which we've published on our website, we asked practitioners, like, what's the purpose of bail? And some believe that if there's money on the table, you're going to show up, right? Because you don't want to lose that money. Recognize that it's usually not the defendant's money. Right? We learned that from interviews with defendants, that it's their mother or whatever. The research we've done also shows that you're not getting the money back, right? The money isn't coming back to you. If you are convicted, the money is going to be used to pay fines and fees and restitution if it's ordered. We're going to keep a cut of that. The county is going to keep a cut of that as an administrative fee. And so research that the Supreme Court's Pretrial Implementation Task Force did found that the majority of money that's posted for bond does not go back to the defendant. So that's another thing about that logic that's challenged. But we also heard from practitioners that they viewed this as kind of an upfront payment on the fines that you're gonna pay, kind of viewing it as a punishment before the conviction. So there were a lot of different rationales for why we use the money, but empirically we know that it doesn't go back to the defendant. Those people that post money aren't necessarily more likely to show and not, and part of it again is because it's not their money and they're not getting it back. So, but that's the one thing we can definitively say is money's no longer part of the decision. And as we hear people debate the policy, we're no longer hearing people say we should bring money back, right? That's kind of behind us in terms of the policy debate. Now the policy debate is, should we change who's eligible for detention? But no longer are we hearing we should bring money back to this process. So, all right, thanks everybody.